The declarations of states dissociating themselves from consensus are to be found under tab 1.3 of today's Judges Bundle. By disregarding all this, the Human Rights Council departed from the framework set by the United Nations General Assembly for fact-finding missions. Indeed, Resolution 4659 of the General Assembly, passed on the 9th of December 1991, which you will find under tab 1.4. The resolution, as I was saying, insists on the need to secure the prior consent of the territorial state for the sending of a mission, and also on the fact that the state may refuse said consent. According to paragraph 6 of the resolution, the sending of a United Nations fact-finding mission to the territory of any state requires the prior consent of that state, subject, of course, to the relevant provisions of the Charter of the United Nations. So, subject to the powers of the Security Council, basically. Now, admittedly, these provisions relate to the access to the territory of the state concerned and not to the establishment of the mission as such. But without such access, it will be difficult for the mission to serve its purpose, which is indeed to assist in the UN competent organs to, and I quote, endeavour to have full knowledge of all relevant facts. Therefore, the consent of the state concerned, while not affecting the legality of the establishment of a fact-finding mission, it does indeed weigh heavily in the success of the mission. To impose a mission on the territorial state without taking the time to discuss it may indeed facilitate its establishment, but does not guarantee its success. The second reason for which Myanmar is suspicious. First, and that is that the Council has shown bias in the definition itself of the mandate of the FFM and IIMM. And this partial approach, this biased approach, is very clear in paragraph 11 of the resolution establishing FFM, according to which, and I quote, the mission is to establish the facts and circumstances of the alleged recent human rights violations by military and security forces and abuses in Myanmar, in particular in Rakhine State. Thus, the FFM was mandated not to establish the full complex facts, amongst other things by distinguishing what was attributable to ARSA, but only to establish what may incriminate the state organs, especially the army and the police forces. Here too, the Council chose to depart from the resolution, the General Assembly's resolution I mentioned previously. Paragraph 3 of said resolution provides, and I quote, that fact-finding should be comprehensive, objective, impartial, and timely. Moreover, according to paragraph 5, in deciding if and when to undertake such a mission, the competent United Nations organs should bear in mind that the mission should contribute to building confidence and diffusing the dispute or situation while avoiding any aggravation of it. End quote. So the FFM and the IIMM later were established on the basis of division and confrontation rather than cooperation. Myanmar never ceased denouncing this incriminating mandate of the FFM, but to no avail. And the preliminary report of 2018 finally convinced Myanmar of the mission's bias, insofar as it clearly ignores the role of ARSA in the confrontation and the loss of life and destruction. Quite clearly, the Human Rights Council did not try to cooperate with Myanmar to establish facts, but rather to impose a biased inquisitorial procedure. Yet, cooperation goes both ways. It is a process, a two-way street in which both parties meet each other's concerns. Yet from the very beginning, the Council quite simply ignored the legitimate concerns of Myanmar, and Myanmar shouldn't be held sole responsible for the failure of the process. Contrary to what says Professor Sand said, I do not believe that a criticism, a well-grounded criticism of a UN mission and its work would in any way weaken similar subsequent missions or the UN as such. On the contrary, it may lead to the improvement of the process. And can I also state that since 2011, IIMM has been and has remained active, and the Human Rights Council still reviews its work without the Naypyidaw government being able to share its point of view in the Council. Indeed, I must recall that the current government is still not accredited at the United Nations and is therefore not entitled to sit and take the floor in any UN body. In such circumstances, there was no guarantee for Myanmar that cooperating with these bodies would have allowed for the corroboration or, on the contrary, refutation of the facts, as Judge Gomez Robledo seems to hope.
I now come to the obligation to cooperate under the Convention. As Myanmar has shown in its written pleadings, neither the 1948 Convention nor even the UN Charter impose upon it an obligation to provide access to the FFM and the IIMM to its territory, or to provide them with information. The mere mention of the obligation to cooperate in the preamble of the Convention Against Genocide is no basis for such an effect. On the one hand, the preamble carries no autonomous normative value and does not create an obligation or any obligation in and of itself. On the other hand, cooperation is provided for. The cooperation that is provided for is foremost a cooperation in order to adopt an appropriate legal framework, that is to say, the Convention itself. Indeed, Resolution 96-1, to which the preamble refers, provides that states recommends that international cooperation be organized between states with a view to facilitating the speedy prevention and punishment of the crime of genocide, and to this end requests the Economic and Social Council to undertake the necessary studies with a view to drawing up a draft convention on the crime of genocide. So, beyond the preamble, the obligation to cooperate is provided for under Article 6 of the Convention, but it is also confined and limited by its provisions, because it provides for trying of those responsible for genocide by an international criminal court having jurisdiction over the contracting parties who have recognized that jurisdiction. As I underlined last week, in the Genocide in Bosnia case, the court considered that Serbia had an obligation to cooperate with the International Criminal Tribunal for the former Yugoslavia, because on the one hand, this was a jurisdictional body set up by the Security Council, and therefore it had jurisdiction, and on the other hand, Serbia had recognized its jurisdiction. The FFM and the IIMM have none of these features. They are not jurisdictional bodies, and their mandate hasn't been recognized by Myanmar. For these reasons, the Convention creates no obligation to cooperate with them incumbent upon Myanmar. And I would finally add that the court itself refused to impose upon Myanmar any obligation to cooperate with those bodies, even though the Gambia has called upon you to do so as part of the Provisional Measures procedure. I now come to the last part of the question. In this final part, Judge Gomez-Robledo recalled the obligation that falls upon the parties to cooperate with the court itself in evidentiary matters, referring to the pulp mills case and that of the genocide in Croatia. This obligation to cooperate in bringing out the truth undoubtedly exists, but it implies in no way an obligation to cooperate with third bodies, such as the FFM and the IIMM. In both these cases, the court referred to the providing the other party and the court itself, upon request, with some specific documents. In the present case, the Gambia did not ask Myanmar to supply any documents. On the contrary, it is Myanmar who made such requests to the Gambia and to the IIMM. The responses to these requests were very sparing indeed. My colleagues have highlighted to great enough an extent what are the consequences of not sharing information that is essential to assessing the credibility of evidence provided by the applicants, and I shall not return to that. In this context, to Judge Gomez-Robledo's final question, what conclusions should the court draw from the refusal of the authorities of Myanmar to cooperate with the bodies mandated by the United Nations to investigate the facts? To that question, Myanmar's answer can be very straightforward indeed. None. No conclusions. The court should draw no conclusions from this lack of cooperation because nothing in the Convention and nothing in procedural law can lead it to draw negative inferences from a decision that is fully at the discretion of the defending state. And it's all the more the case when the lack of cooperation stems from grounds as legitimate and justified as those I have just presented. I now come to the obligation to punish. In terms of law, I have little to add to what I said during the first round. Actually, our learned colleagues across the aisle shied from a legal debate and preferred to address arguments that Myanmar did not put forward and grossly twisting those that it did. Our colleagues admittedly gave themselves little time to discuss the law. Now, of course, there are some major points of agreement between the parties, at least two. We agree that the obligation to punish is triggered only if the court determines that a genocide has been committed. Thus, this counter-responsibility indeed plays a subsidiary role. We also agree that the obligation to punish includes an obligation to investigate and, where appropriate, to prosecute and to try. In both cases, the territorial state has some discretion. But there remain many points of disagreement, and the court will probably have to rule on some of them. On a theoretical level, are impunity and destruction of evidence capable of substantiating dolus specialis? The Gambia continues to allege it without providing support to its arguments. Secondly, under what conditions is the obligation to investigate triggered? Is there a threshold or a triggering standard as you established in other cases? The Gambia said nothing of it in the second round, whereas it had suggested several standards throughout the proceedings. In writing, it referred to existence, and I quote, of sufficient basis for knowledge that genocide has occurred.
Sufficient basis for knowledge that genocide has occurred.
It also put forward another standard, that of sufficient evidence of genocidal acts. In English,
sufficient evidence of genocidal acts.
In the hearings, it mentioned the standard of reasonable grounds.
Reasonable grounds.
And in its final submissions, the Gambia uses yet another concept, since it purports that Myanmar should take to justice those members of its security forces and other persons falling under its jurisdiction suspected on probable grounds of having committed acts of genocide. That is a quote. In the English,
suspected on probable grounds of having committed acts of genocide.
In terms of law, we no longer know which standard to turn to. In practice, we can say if, according to the Gambia, it is enough for accusations of genocide to be made by NGOs or even the FFM for an obligation to punish to be triggered. Third question, on which we still disagree. Must a state alleging the breach of this obligation have previously identified the individuals whom the territorial state is supposed to investigate on? As I said during the first round, your jurisprudence goes along those lines. But in legal debate, Professor Pierre Dargent preferred the rhetorical question. Must I really respond to this argument, he said? The court will tell. I note, however, that in its written pleadings, the Gambia had identified 6 individuals by name, demanding that Myanmar prosecute them, specifically on the basis of command responsibility. These 6 individuals had, what's more, been referred to by name in the submissions formulated in the written phase. This was mentioned by Mr. Pierre Dargent when he put into question the existence of such a form of responsibility in the convention. Then the name of these 6 commanders, however, disappeared from the final submissions read at the end of the hearing by the agent for the Gambia, and we must conclude that the Gambia has given up the specific requests regarding them. So that covers the obligation to punish under the law. What about the facts? Myanmar had substantiated in writing, including within the periodic report on the implementation of provisional measures, its efforts in terms of investigations and prosecution, as well as obstacles met. The mockeries of the Gambia force me to come back to this point, and I will do so by looking at 3 bodies whose work is intertwined. The Independent Commission of Inquiry, the body tasked with investigations and criminal prosecution, and military courts. The Independent Commission of Inquiry. This was set up in 2018 by the Myanmar government. This was a hybrid commission made up of 4 members, 2 international experts and 2 Myanmar nationals. And I would like to name them. Ms. Rosario Manolo, former ambassador of the Philippines, former president and rapporteur of the Committee on the Elimination of Discrimination Against Women. She was the president of the Commission of Inquiry. Mr. Kenzo Oshima, former ambassador of Japan and Deputy Secretary General of the United Nations for Humanitarian Affairs. Those were the international members. Regarding the national members, there was Judge U Myatain, former president of the Myanmar Supreme Court, and Professor Aung Tun Tet, chief coordinator of the Union Enterprise for Humanitarian Assistance, Resettlement and Development in Rakhine State. The Commission was assisted by national and international legal and technical experts selected on the basis of their knowledge and experience. The Gambia vigorously contested or put into question the independence of this commission. I don't think there's a need to pull up the respective CVs of its members to convince you of how serious this commission was. Its work speaks for itself. The commission's mandate was much broader and less biased, it must be said, than that of the FFM. Indeed, there was no assumption of responsibility, since it was asked to, and I quote its mandate,
violations and related issues following the terrorist attacks by the Arakan Rohingya Salvation Army in Rakhine State, with a view to seeking accountability and formulating recommendations on steps to be taken to ensure peace and stability in Rakhine State.
The Commission did not have the power to establish facts definitively, nor to engage in trigger prosecution itself. It was tasked with gathering and contrasting information from different sources in order to issue recommendations to the competent bodies. These recommendations were then to be followed up by more in-depth investigation with a view to triggering prosecution. The Commission benefited from extensive investigation powers, including regarding searching for documents, summoning witnesses, or carrying out in situ inspections. The investigations bore mainly on 6 serious accusations: mass killings, rape, destruction of property, looting, torture, and forced displacement. The Commission set up 2 working groups. The first focused on interviews with the witnesses in 13 specific locations, including about 60 villages. Specific locations where major incidents had been reported. It heard from more than 1,000 residents. The second team carried out interviews with 298 witnesses, including 249 villagers and 49 security officers, military and police.
Il a lancé des appels à contribution en anglais, en Myanmar.
And it issued calls for contributions in the English, Myanmar, Rakhine, and Bengali languages, with the aim of gathering testimonies, evidence and documents related to the incidents. It collected statements from various communities, Muslim and other ethnic minorities, members of the security forces, the Tatmadaw police. However, some interviews, particularly with people in refugee camps in Bangladesh, had to be conducted by telephone, as neither Bangladesh nor the competent international organizations provided the necessary assistance to organize its work in the camp. The Commission also emphasized the importance of cross-checking statements, thus collected, with other credible information, noting that witnesses do not always remember the entire truth or that they may be under influence. The teams visited the sites of the incidents to verify the allegations made. In addition to witness testimony, the Commission incorporated administrative data, police reports, and information on ARSA tactics in reaching its conclusions. Demonstrating its impartiality, the Commission found that serious human rights violations had been committed during the operations, some of which likely involved members of the Myanmar security forces. Tab 1.5 of the judge's file contains the most significant excerpts from the Commission's executive summary. The summary was published on the website of the Presidency of Myanmar on the 20th of January 2020, together with Annexes 16 to 28, which summarize the situation location by location. The Commission's final report, as well as Annexes 1 to 15 and 29 to 31, remained confidential, but the documents that are available give an idea of the seriousness of the Commission's work. After highlighting the possible violations, the Commission concluded that these facts should, and I quote in English,
verified and thereafter prosecuted by Myanmar's national legal processes, in particular its military justice system. The incidents in the 13 areas contained in the main report will require more comprehensive investigations by the Myanmar authorities and Myanmar's defense services. Fin de citation.
So this is one of the bodies that the Gambia describes as a bogus or sham institution. Is it really? I would venture to compare it with the FFM based on the three criteria by which the Gambia assesses the credibility of reports. And you may remember these three criteria: care taken in the preparation of a report, the diversity of its sources, and the independence of the persons responsible for its preparation. Does the Commission's hybrid composition make it less independent than the FFM? And if so, which members make it so? Are its working methods less reliable? If so, why? Are its sources less diverse? I would say, on the contrary, because while the FM relied almost exclusively on testimony gathered in the camps, the Commission drew on a variety of sources from all sides, including testimony gathered in the camps, even if the conditions were not ideal. The final result demonstrates the impartiality of the approach used by the Commission. And unlike the FFM, the Commission did not focus solely on finding evidence incriminating Myanmar, but examined possible responsibilities on all sides. In this context, Gambia's allegations, which in fact echo those of the IIMM, are derisory and unfortunately demonstrate that a double standard is being applied. The fact that one member of the Commission allegedly made contentious statements and that one member of the Secretariat was allegedly part of Myanmar's ICJ team is put forward, according to Gambia, as a major conflict of interest. What then can be said about the fact that the chair of the IIMM provided an affidavit in support of the Gambia's position, and that members of the NGOs that provided evidence to Gambia are also members of the Gambia's ICJ delegation? The Commission's findings served as the basis for the Criminal Investigation and Prosecution Body, which was set up in 2020. The composition in terms of reference of this body are contained in tab 1.6 of the judge's file. It comprises representatives of the civil authorities responsible for law enforcement and prosecution, including the Myanmar Police and the Prosecution Department of the Office of the Attorney General of the Union. Its jurisdiction extends to members and collaborators of ARSA, to the police and to civilians. However, it does not apply to members of the Tatmadaw who acted in the course of their duties, as they come under the military justice system, and I will come back to this shortly. In concrete terms, the body must deal with the 139 cases identified by the Independent Commission of Inquiry. The status of its work is as follows, and I apologize for this long list. Of the 87 cases involving ARSA members, 12 resulted in prison sentences ranging from 10 to 20 years. 11 cases were dismissed due to lack of evidence. Of the 29 cases involving civilians, 3 resulted in prison sentences. And in May 2025, men were sentenced to 10 years in jail for deliberately setting fire to the village of Chutpin. 23 cases regard the police. Some have been closed without further action, while in others, proceedings have been suspended. 2 cases have resulted in disciplinary sanctions. And on this point, I can confirm that Professor D'Argent's tally of these latter cases, the police cases, was correct. However, that tally does not include or mention the other investigations and the reasons why some of these investigations are stalled, namely the fact that some of the police officers involved are on the run and the unstable security situation in northern Rakhine State makes investigations difficult. But the body is pursuing its work. Now, as for members of the military, they have been prosecuted before courts martial, and I will not revisit here the grounds for jurisdiction over military personnel, nor will I revisit the convictions of 4 officers and 3 soldiers for the Indin massacre. Based on the recommendations of the Independent Commission of Inquiry, the military court also tried military personnel, and I will briefly summarize these convictions, but I confirm from the outset the accuracy of Professor D'Argent's account. In the Gud Dar Pin case, the verdict established that a non-commissioned officer had violated the rules of engagement and that 2 officers had failed in their supervisory duties. The latter were sentenced to 1 year in prison with hard labor. One of the officers and the non-commissioned officer were sentenced to 1 year in prison with hard labor, while the senior officer was punished by having 1 year of service deducted from his pension calculation. For Maungnu, 1 officer was convicted of negligence and 2 soldiers for criminal use of force against civilian women, sentences of 1 and 2 years imprisonment with hard labor, respectively. For Chutpin, the case remained at the preliminary investigation stage. A special commission of inquiry was formed anew and visited Butidang in February-March 2023 to collect testimony from civilians, both Bengali and Rakhine. The commission of inquiry contacted local administrators to obtain more information. It was established that the inhabitants of this village and the surrounding area have not returned there and do not live nearby, which is preventing the investigation from progressing. But the case remains open. The court will decide, if necessary, on the basis of the status of proceedings, whether the investigations conducted were sham investigations. On the other hand, in his oral pleading, Professor D'Argent did not refer to these investigations, but highlighted the total impunity of the alleged instigators without providing any legal or factual basis for an obligation to punish them. Having given an overview of the bodies involved in the process of suppression, I can now attempt to respond more directly to the joint question by Judges Charlesworth and Pillay, which you see on the screen. And it concerns the measures taken by Myanmar to investigate allegations of sexual violence and their outcome. Judicial investigations into allegations of sexual violence are progressing with difficulty in the absence of complaints from victims, principally for those located outside Myanmar, or when complaints have been filed but were filed long after the events. On this precise point, I also note that the Independent Commission of Inquiry did not receive any conclusive information during its investigations, since, according to the executive summary in tab 1.5 of your hearing file, and I quote,
to rape. There were no credible statements on allegations of gang rape committed by Myanmar's security forces. Although some interviewees mentioned rape cases, these were all second-hand information heard from someone else. Additionally, some female witnesses noted that they were searched by male Myanmar Defense Services personnel as a part of the operations. This behavior may amount to constitute sexual violence. Fin de citation.
To answer even more precisely, according to the information that the government of Myanmar provided us with in order to answer this question, I can inform the court that charges were made against a corporal and a soldier for sexual misconduct. This incident took place on August 27, 2017, in the village of Mong Nu. Following the investigation, the corporal was dismissed from service and sentenced to 3 years in prison. The soldier was sentenced to 1 year in prison in a military prison. Furthermore, a disciplinary sanction was given to the major of the Yangon Command Headquarters, who himself was the commander of the column during the incident. This information was provided to us in a letter sent by the Ministry of Defense, and Myanmar is at the court's disposal to provide the supporting document if need be. Still, on sexual violence, there has also been a court case for rape of a Rakhine woman by 3 soldiers, but the incident is alleged to have taken place in 2020 in the Ratadung township, so in a period that does not concern the operations directly. I would like to say, however, that according to the information provided by Myanmar and other reports on the implementation of provisional measures, the soldiers were tried before a martial court for sexual violence and sentenced to 20 years in prison with forced labor. So much for the answer to the question on investigations of sexual violence. Mr. President, let me now address the last topic of my presentation, which concerns the destruction of villages. This will allow me to answer the joint question put by Judges Charlesworth and Pillay on the number of villages destroyed and who was responsible for said destruction. In fact, it is not so much of an answer to the question that I will give, but rather an explanation of the reasons that make it impossible for Myanmar to give a precise answer to this question. The number of destroyed villages, according to the Gambia, is based on a document coming from Genocide. This document reports 392 Bengali villages that would have been partially or completely destroyed in northern Rakhine State between August 2017 and March 2018. The date of the end of data gathering is March 2018 and not October 2018 when the map was published. This has no major effect. I will return to this document shortly. Allow me, however, to recall that Myanmar has never denied the existence of affected villages during the operations conducted against ARSA. The information gathered by the government in situ are, however, incomplete. Right after the incidents, the National Human Rights Commission conducted a field visit from September 24th to September 27th, 2017. However, because of the deteriorating security situation in the region starting in 2019 and especially from 2021, this deteriorating situation made it impossible to conduct further investigations or to further pursue ongoing ones. Now, regarding the work of the Commission, in September 2017, the National Human Rights Commission tallied 192 villages or neighborhoods that were partially or totally destroyed. The report also mentions 29,000 houses that were destroyed out of a total of 104,000. That being said, this tally is only for the Mengdao township, whereas Genocide also covered Budidong and Radidong. Additionally, the Commission's report covers Bengali, ethnic, and mixed villages, whereas the Genocide only takes stock of Bengali villages. The court also has the summary report of the Independent Commission of Inquiry that I've already referred to. This is what we learned there.
That those houses and other structures were deliberately set on fire by Myanmar security forces personnel and even by local ethnic nationals, local vigilantes. It was also noted that witnesses stated that ARSA fighters themselves torched their own houses and other Muslims' houses. Interviewees' information suggests that most destroyed village structures were burned down after ARSA fighters and Muslim residents left.
This observation flows from the testimony gathered by the Independent Commission of Inquiry in the 13 locations where major incidents took place in August 2017 in the townships of Mengdao, Budidong, and Radidong. Amongst these locations are the three main locations, that is Mingji, Mengnu, and Chupin. The work of the Commission show how difficult it is to identify the perpetrators of these incidents, generally speaking, whereas the Rakhine, Hindu, and Mro witnesses claimed that either ARSA or Muslims are responsible. The Muslim witnesses, in turn, blame the security forces or Rakhine civilians. Others say that ARSA is responsible for the devastation. Thus, according to two Muslim witnesses in the north of Mengdao, and here again, I am citing one of the annexes that's appended to the Commission.
To have torched Ti Ki Pin and Nang Da Kali villages during the first week of September. Village elders from the two villages had provided a list of villagers who participated in the attack on the police outpost, and ARSA burned the two villages as a revenge. Fin de citation.
The document that Gambia relies upon do not shed any more light, be it on those who are responsible or the purported figures. Gambia, nonetheless, says that the document provided by UNICEF on October 18, 2018 is undeniable evidence that these allegations are true, and it adds,
Only showing that UNOSAT was wrong. No. Avant de répondre,
before answering this question, let us first ask what UNOSAT's work involves. It involves the comparison of satellite images of the same location at different dates in order to interpret the observed changes. UNOSAT's role is not to make any findings on potential responsibilities for these changes. As we can see in the caption of the 2018 map.
on settlements indicate that approximately 392 towns and villages from a total number of 1993 were affected. Pas d'attribution.
No responsibility is assigned. Therefore, UNOSAT's report tells us absolutely nothing about those who are responsible for said destruction. The Gambia's council blithely ignores such a detail. In their view, the Myanmar authorities are necessarily responsible for all the damage caused by fire. They consider that any village in any way affected by fire is a consequence of military operations and thus can be attributed to Myanmar. However, we have just seen that the investigation and the testimony gathered in the field do not allow for such definitive findings. Far from it. The UNOSAT document that Gambia relies upon actually corroborates this. The enlarged box that you have before you show two satellite images of Hotikong. The first on September 16, 2017, the second on September 25, 2017. We see that village stayed intact at least until September 16, 2017. Likewise, in another document provided by UNOSAT, the fire detection data in the area shown in the box shows that there were two periods when the fire intensified. The first was from August 25th to August 29th, so during the period of operations, and the second was from September 14th to September 18th. However, Myanmar has shown that the military operations ended on September 5th, 2017. The destruction of the village that we just saw and the second episode of intense fire took place after the end of the operations. On what grounds is the Gambia attempting to ascribe this to Myanmar? Its council have tried to sidestep this difficulty by engaging in a circular reasoning. Because there were fires, it means that the military operations had continued, and it follows that the fires can be attributed to Myanmar. Let me now turn to the systematic demand placed upon Myanmar to disprove, point by point, the circular reasoning engaged in by Gambia, which it presents as intangible truth. Thus, according to the Gambia's council, the figures put forward by UNOSAT are necessarily true because they come from UNOSAT. These figures can only be true because the IIMM takes them at face value. They are so true that the Gambia rests most of its argument on said figures. But this goes beyond just challenging the facts or the figures as they are presented. What's at stake here is the question of whether the proceedings are fair and whether the principle of adversarial proceedings is fully respected. This is the frame of mind that led the Gambia to present as its ultimate evidence the public summary of the IMM of September 29, 2025, a summary that is focused, and I quote, the destruction and dispossession of Rohingya land and property during the clearance operations 2017. As regards the affected villages, this summary refers almost exclusively to a confidential report of UNOSAT that is titled
Damage and Security Assessment on behalf of the Independent Investigative Mechanism for Myanmar.
Why is this report confidential if they are a satellite image? This is something we'll never know. But it is cited no less than 34 times in the summary presented by the mechanism. However, according to its authors, the summary of September 29, 2025, and I quote it,
facilitate proceedings in national, regional, or international courts. D'ailleurs, le rapport complet.
Furthermore, the full report is
national authorities to facilitate investigations and judicial proceedings.
And yet, here we are. We are here in these proceedings, but we must be contented with a summary extracted from a confidential report. Here we are in these proceedings, but Myanmar has to respond to a document of which most of the references have been either expurgated or are inaccessible. The Gambia's council have used this as their key piece of evidence to assign most of the destruction to the government of Myanmar. We heard them say,
clear and provided in the IIMM report itself. Myanmar had next to nothing to say in response.
If this is how the Gambia's council conceive fair evidence and adversarial proceedings, we may be facing another dispute, but such a dispute would not come within the purview of these proceedings, and we can continue, if need be, this debate in connection with different proceedings. I've finished with my presentation. Allow me, before giving the floor to my colleague, to thank all of my colleagues for their professionalism, the court for its courtesy, and of course all of you, members of the court, for your kind attention. I would like to ask you, Mr. President, now to give the floor to Mr. Blom-Cooper. I'd like to thank Professor Myron for her statement.
Mr. Sam Blom-Cooper to address the court. You have the floor, sir.
Thank you.
Mr. President, distinguished members of the court, good morning. My presentation this morning will respond to the Gambia's further oral submissions last week, claiming that genocide has been proved. Myanmar maintains that nothing submitted by the Gambia in either its oral submissions nor during the course of the witness evidence heard last week disturbs the position that the Gambia has failed to prove, to the requisite standard of proof, either the actus reus of genocide or the dolus specialis. At this stage of proceedings, no one thanks an advocate for unnecessary repetition. So, I do not intend to say anything further about the actus reus, as Myanmar has already set out in full its position in respect of each of the paragraphs A to D of Article 2, such that the actus reus of genocide has not been established. Instead, my intention is to focus on the issue of dolus specialis, and more specifically, I will address the newly emerged theory on genocidal intent advanced by the Gambia for the first time through its expert witness and in its second round of oral argument. The Gambia, following in the footsteps of the FFM, has previously tried to establish a new indicators of genocidal intent approach. The Gambia sought to use 7 so-called indicators which were said to establish the genocidal intent. For the reasons given by Professor Tauman during the first round, this approach is plainly wrong. The Gambia's scant reference to it during the second round very much suggests that he was right. In this newly formulated approach, Professor Newton now claims that a genocidal intent is to be found from what he suggests to be a consistent modus operandi to the military operations, and that, quote, which replicates itself in over 54 documented instances and is so consistent across all places throughout northern Rakhine State. As Professor Newton stated in terms, quote, my factual findings were based on what the FFM said, and the findings there with respect to a modus operandi. They identified 54 corroborated instances and another 22. I had no fact-finding ability, so I relied on the facts as stated in the FFM, the full FFM. Before turning to address this new theory in substance, I recall two important points of Professor Newton's expert opinion. First, in the absence of independent fact-finding by Professor Newton, he is no better placed than this court in assessing the facts as contained in those FFM reports, or in determining what inferences may properly be drawn from the circumstances and the facts. However, those tasks, namely what weight, if any, this court can properly place on the statements of fact contained in those reports, and what inferences may properly be drawn, are of capital importance in this case. You have received comprehensive submissions from Dr. Staker on this issue, and in Chapter 6 of Myanmar's written pleadings. There is nothing that Professor Newton can say that adds weight to the facts contained within those FFM reports. The second point concerns the various opinions that have been expressed by Professor Newton on whether genocide has been established. You were addressed by Mr. Hooper yesterday on this, and I suspect I would struggle to improve upon the submissions that he made over Professor Newton's conclusions. As highlighted by Mr. Hooper, the evolution of his expert opinion over time is revealing. From a complete absence of mention of ARSA to a recognition that it represented, quote, a serious insurgency. However, one matter stands out from his evolved opinion, a matter that the Gambia has quietly sidestepped in this case, and it is this. In May 2024, some 3.5 years after providing his first expert report, Professor Newton provided his second expert report. In it, he describes having reviewed the Counter-Memorial of Myanmar, having considered Myanmar's rules of engagement, and having noted that such rules of engagement largely reflect internationally recognized standards. And finally, he describes having examined indiscriminate attacks on Rohingya civilians and the alleged widespread physical and sexual violence said to have characterized such alleged attacks. Having done so, Professor Newton then says this: widespread and indiscriminate attacks directed at entire segments of a civilian population are so obviously incompatible with genuine counterinsurgency that they warrant the inference that the government's objective is not to defeat an insurgency, but to punish or destroy the civilian population in whole or in part. This is the Gambia's own witness. Their expert apparently telling this court that one reasonable inference to be drawn from widespread physical and sexual violence as part of indiscriminate attacks on a civilian population is an intent to punish that civilian population. If that is right, then an intent to destroy the protected group in whole or in part would not be the sole reasonable inference to draw, and genocidal intent will not be established. The Gambia's claim would fail for the same reasons the court gave in the Croatia case. Professor Newton, of course, ultimately stated that it must be genocide, but that is a conclusion, as Mr. Hooper noted yesterday, that is little short of a quantum leap in unsupported logic, and one that took him outside of his military expertise. Mr. President, members of the court, let me now turn directly to the live testimony of Professor Newton. and his new theory of a consistent modus operandi, allegedly reflecting the manner in which all counter-terrorism operations were conducted throughout northern Rakhine State during August 2017, and from which it is said a genocidal intent may be inferred. Professor Talman will address the court this afternoon on the legally misconceived method by which Professor Newton and the Gambia now invite an inference of genocidal intent. For the reason to be given, not only does this new proposed approach not accord with the court's own case law, but it improperly seeks to short-circuit the court's task. This court has previously held that an examination of all the facts is required in order to assess whether the applicant has established a consistent pattern of conduct arising from factors identified by the court, namely the scale and systematic nature of alleged attacks, whether excessive casualties and damage were caused, whether there was specific targeting of the protected group, and the nature and extent of injury caused. It is only once the court is fully convinced that such a pattern of conduct is established that the court proceeds to consider whether genocidal intent may be inferred from the established pattern, and whether it is the only reasonable inference to be drawn. A modus operandi refers simply to the individual attacks themselves, while the pattern of conduct looks at the bigger picture. While a pattern of conduct may consist of widespread attacks, according to a, quote, generally similar modus operandi, unquote, such attacks on their own do not establish a pattern of conduct. In short, modus operandi is not to be conflated with pattern of conduct. At the outset, you will know that it is specifically to the alleged modus operandi said to characterize the August 2017 counter-terrorism operations that I must and will direct my submissions. That is because Professor Newton did not find any such modus operandi characterizing operations of October and November 2016. His instructions, such as were provided over the telephone, conspicuously directed him to, quote, assess the modus operandi, the pattern of practice post-25th of August against the established counter-insurgency doctrine, unquote. Neither Professor Newton nor the Gambia has seriously attempted to explain how events in October and November 2016 were characterized by any form of modus operandi at all, let alone by the one that Professor Newton now claims is applicable to the August 2017 operations. More importantly, and consistent with the case law of this court, there is no sense in which the military operations of 2016 formed any part of a pattern of conduct from which a genocidal intent could properly be inferred. The court will nevertheless recall that the Gambia's case in respect of those operations is that they took place within a tightly confined geographical scope and lasted just 2 days in each month, during which a total of 47 killings are alleged to have taken place across 11 different locations. How the 2016 operations fit into any part of the Gambia's case theory is frankly a mystery, and it remains unsolved at the end of these hearings. Turning now to examine the details of Professor Newton's new theory for the 7 days in late August 2017, 2 matters are of note. First, that during more than 5 years since that he was first engaged as an expert, and having submitted 2 expert reports in October of 2020 and May 2024, and a written affidavit as recently as November 2025, it is only last week, during his live testimony, that Professor Newton referred for the first time to the existence of the alleged modus operandi characterizing the 2017 operations, and from which he now suggests an inference of genocidal intent should be drawn. Second, not only does the term modus operandi not once appear in any of his previous reports, but nor does the list of 10 specific elements which are said to define the so-called modus operandi. In any event, aside from the fact that there is no legal basis underpinning this newly formulated theory, the theory fails on its own terms, as the evidence simply does not show what Professor Newton says it does. Professor Newton claims that the following 10 elements define the alleged modus operandi that characterized each of the August 2017 operations. They are 1, surrounding Bengali villages or parts thereof; 2, surprise attacks; 3, attacks from different angles; 4, indiscriminate shooting at civilians; 5, segregation of men and boys from women; 6, mass rape of women; 7, executions; 8, shooting at fleeing refugees; 9, burning houses or areas; and 10, bulldozing. Having identified these 10 elements, Professor Newton then concludes categorically and emphatically, quote, "That entire pattern replicates itself in over 54 documented instances, and that's the basis of my opinion," unquote. That conclusion, however, is obviously wrong and unsupported by the very evidence from which he claims it to emerge. To demonstrate this, Myanmar has reviewed once more the entirety of the FFM's 2018 and 2019 reports, and the following table lists all 10 alleged elements of the modus operandi that are said by Professor Newton to be present in more than 54 locations and based upon the FFM reports. You have within your folders at tab 2.2 what is now broadcast onto the screens. The locations examined by the FFM are listed vertically for each of the 3 townships. Contrary to Professor Newton's contention that the entire pattern of all 10 elements is present in more than 54 locations, there is in fact not a single location where all 10 elements are present. Only one location, namely Minji, is alleged to be characterized by 9 elements. The large majority only have 1 or 2 elements allegedly present, and even then, the represented elements are not even generally consistent across multiple locations. In short, analysis of the FFM reports demonstrate that the modus operandi, as claimed by Professor Newton, did not exist. Mr. President, before leaving the testimony of Professor Newton altogether, it is also instructive to examine the answers that he gave in response to questions of the court. In particular, his answer to the question posed by Judge Hamoud as to how any military force might legitimately deal with insurgents who are not readily distinguishable from the population from which they are drawn. In response, Professor Newton acknowledged that the situation faced by Myanmar was a serious insurgency, and that such pernicious and difficult situations may well require partially military solutions. Professor Newton identified 2 key approaches to counterinsurgency to be pursued alongside such military solutions. The first feature identified was, quote, "getting better intelligence collection," unquote. Myanmar agrees with that proposition, and it is precisely what Myanmar sought to do in respect of ARSA. As the evidence shows, Myanmar consistently took concrete steps over many months seeking to gather intelligence and build up a clearer understanding of ARSA and its operations. It did this through a network of informants within local communities. Indeed, the FFM devotes an entire section of its 2018 report to the issue of killing of Rohingya informants. While it is clear that Myanmar used this network of intelligence sources to understand the reach, capabilities, and activities of ARSA, it is equally clear that ARSA repeatedly resorted to extreme and widespread measures, including killing dozens of informants, to prevent information about its intended violence becoming known to the security services. As the FFM stated, ARSA, quote, used threats and intimidation, including violence against the population, to protect its plans and activities and to ensure secrecy. Informants, known locally as Tabe, were present within the Rohingya community and provided information to the Myanmar authorities. ARSA took steps to control them, including beatings and killings. In the period following ARSA's attacks of October 2016 up to June 2017, the evidence suggests that no fewer than 50 informants were killed by ARSA. A good example is U She Kya village tract in Mongdor Township. Here, the names of 8 local ARSA members were given to the Border Guard Police. Acting proportionately upon the intelligence received, the Border Guard Police carried out targeted night raids and arrested those suspected of the ARSA-related activity. However, 2 Bengali informants were killed by ARSA as a result. The most important example, however, concerns the third of the Gambia's 3 main locations, namely Maung Nu. Events at Maung Nu also contradict Professor Newton's assertion that there was a failure by Myanmar to use discriminate force. Witness P1496 describes how there were 3 people in Maung Nu who were in charge of ARSA, one of whom was a man called Zahid Hussain. 2 to 3 days before ARSA's August attacks, Zahid Hussain and other ARSA members captured 3 informants during daylight hours and in front of their families and neighbours. One was murdered shortly afterwards, his throat cut. Then, on the 25th of events on the 25th of August 2017 itself, P1496 describes how, quote, Zahid Hussain proudly carried bombs and told a crowd of people watching that they were going to test these weapons, unquote. It was thus widely known within the village by this stage that Zahid Hussain was centrally implicated in the murder of local villagers and was parading bombs openly in Maung Nu. And this is the context in which the testimony of witness M.N. falls to be considered, alongside the observations of Mr. Hooper from yesterday. While witness M.N. denied any knowledge of ARSA, it is noteworthy that out of a population of some 4,600 people in Maung Nu, the one house that he immediately went to when told of the military's presence was that of Zahid Hussain. As you now know, that house was the location to which the army headed directly after its initial clash with ARSA. Far from targeting the general population of Maung Nu, the security services concentrated on Zahid Hussain and upon his home address. This confirms the focused rather than indiscriminate nature of the military operation at Maung Nu. This was not the conduct of a genocidal plan. Thus, when Professor Newton stated that during the military operations there was, quote, no effort whatsoever to determine an ARSA location, or an ARSA house, or a safe house, or an IED factory, none whatsoever, it is an assertion contradicted by the available evidence. This is not merely in respect of some secondary or tertiary location, but one of the Gambia's three main locations. The Gambia's own evidence likewise controverts his related assertion that the military carried out surprise attacks with no notice, with no warning, indiscriminate shooting from the get-go. Again, the evidence of MN is that the military went to the house of Zahid Hussein and called for him to come out. There was no shooting from the get-go, or even, on the account of MN, for some hours. The Gambia tells the court that there was no attack by ARSA upon Maungnu itself, and therefore no reason for the military to go to the village at all. As such, the Gambia asks you, the court, to ignore ARSA's attack upon the border guard post at Apang Tor Pin, which should merely be considered, quote, peripheral events taking place at some distance, unquote. The peripheral events in question being the murder of 2 police officers whose throats were cut, and the some distance in question being not much more than 500 metres away. It is a matter for the court to consider whether those events might be relevant to what happened in Maungnu. Mr. President, the focus upon targeting ARSA and not the wider Bengali population is similarly borne out by the Gambia's own evidence in respect of Minji, the first of its main locations. In the early hours of the 22nd of August 2017, a week prior to the events in question, quote, the border guard police came to Minji. They went house by house, collecting all of the people in the village and forcing them to go to a meeting, which was held in the compound of the old mosque, unquote. Present at the meeting were the chairman and the head of police, who warned them that there were bad people in Minji and instructed them not to do something bad themselves, nor to provide shelter and support to the bad people. Another witness further describes local Bengalis being directed to dismantle, not destroy, 3 particular houses in the village that belong to people affiliated to ARSA. 2 to 3 days prior to the 30th of August, the head of police convened yet another meeting, this time involving both Rakhine and Bengali villagers. He beseeched, quote, both the Rakhine and the Rohingya villagers, people, that they would not attack one another. This agreement was made on paper and signatures were taken from both parties, unquote. Professor Newton appears to have been unaware of these attempts to de-escalate rising intercommunal tensions, which is at odds with the Gambia's narrative of a carefully choreographed genocidal plan. Here again, the evidence shows targeted law enforcement steps focused on ARSA and the risk of further violence. It reveals warnings to the Bengali population not to harbour or support terrorist activity. It sought the dismantling of just 3 specific structures within Minji that were reasonably believed to be being used by suspected terrorists. Nothing wider. This is precisely the intelligence-centred, targeted approach that Professor Newton commends. Such proportionate, calibrated and intelligence-led counter-terrorism steps were, however, soon submerged, as you now know, when ARSA's campaign of violence began its sweep down the Puma River Valley, from Kalmanzake to Minji, and as described in my presentation to the court last week. The second approach to counter-terrorism advanced by Professor Newton relates to the need for the recourse to municipal criminal justice, in his words, quote, to arrest and prosecute and build criminal cases against key leadership, unquote. Prior to ARSA's 2017 attacks, again, this is precisely what Myanmar sought to do. The court is already aware that following ARSA's 2016 attacks, far from resort to unfettered destruction, those reasonably suspected of involvement in ARSA's attacks were arrested, investigated, charged, prosecuted, acquitted and released, or convicted and sentenced. Not just one or two token gestures, but at least 416 defendants. For the 9 months that followed the 2016 attacks, the Gambia does not allege that any acts of genocidal violence took place at all. Law enforcement and criminal justice continued as Myanmar's means of dealing with ARSA's criminality. Here again, this is in relation to one of the Gambia's main locations that provides insight into the mindset of Myanmar in these circumstances. In mid-July of 2017, just weeks prior to ARSA's attacks, security services arrested 8 men in Chut Pin, of whom 4 were later released, with the remainder detained on terrorism charges. In parallel, Myanmar similarly sought to de-escalate intercommunal violence and intervened during an armed standoff between groups of Rakhines and Bengalis. Rather than seeking to imperil life, Myanmar sought the opposite and did so in respect of Chut Pin. Mr. President, members of the court, I turn now to deal with one particular element of the alleged modus operandi that concerns the claim of pervasive sexual violence. And I do so because it has attracted extensive reference by the Gambia in its oral pleadings and is said by their expert to characterise the modus operandi present in all 54 locations identified by the FFM. As you heard on Monday, however, in answer to questions posed by Judge Charlesworth, the Gambia acknowledges that Professor Newton was wrong in his assessment. The Gambia now says that on the basis of its review of the FFM reports, that instances of sexual violence took place in 10 places across northern Rakhine State, not the mass sexual violence claimed in more than 54 by Professor Newton. It is to be recalled that that is out of 509 locations in northern Rakhine State inhabited by Bengalis in 2017. Even with reference to those 10 places, little detail is provided in the FFM to identify when or in what circumstances many of these alleged instances of sexual violence are said to have occurred. The allegation of widespread sexual violence is denied by Myanmar, and I ask the court to treat with extreme caution the Gambia's sweeping characterizations of such evidence that you have heard in this case. You will recall that the Gambia has variously told this court that mass sexual violence took place in dozens of locations, or that it took place in scores of villages across northern Rakhine State. It now revises its claim once more to assert that it, quote, certainly occurred in a great many locations, unquote. There is a reason why the Gambia cannot identify from where or in what circumstances so many of its serious allegations of sexual violence derive, because the underlying evidence itself, which the Gambia discourages you, the court, from examining, is often so vague and so generalized. There is a further specific aspect of the generalized nature of this alleged criminality, both in terms of the quantitative aspect and its purported geographical distribution, that requires both comment and consideration by the court. It concerns evidence from the US State Department that has been repeatedly been called upon, yet misrepresented, perhaps misunderstood, in support of a claim of a pattern of conduct. Even the most cursory review of this data, however, reveals that it is evidentially worthless. Not only does the underlying survey data upon which it is based, not record and present the actual number of instances of sexual violence. But it covers a period of some 25 months, not merely the 4 days in 2016 and the 7 days in late August of 2017. In short, 98% of the time frame from which the data is drawn and then presented by the Gambia to establish a pattern of conduct has no bearing on the period of alleged genocidal conduct claimed by the Gambia. This evidence is a prime example of why careful scrutiny of the evidence is so necessary. Mr. President, members of the Court, I come now to a different issue, but one which again requires careful examination of numbers and figures. Which ones are relevant, which ones are not, what those numbers mean in the context of drawing inferences, and how ultimately they bear upon the issue of dolos speciales. It concerns the issue of opportunities to destroy the targeted part of the group. On Tuesday, you were presented with a blizzard of statistics relating to a host of matters, such as the population size of Northern Rakhine State, the numbers of villages, populations of different townships, numbers of refugees, ethnic composition of different parts of the region, their respective sizes, the fractions and percentages of fire-damaged locations, and so on. And to what end? Why does the Gambia present 37 different statistics for the Court's consideration? It is in fact clear why they do this: to attempt to artificially shrink the size of the targeted part of the protected group as creatively as possible, while simultaneously inflating the unproven number of alleged victims. As discussed in my presentation last week, in the context of genocide, numbers do matter. I appreciate that that may sound like a somewhat clinical statement, but it is one based upon the jurisprudence which we are all bound by and all have to apply. In the Croatia case, this court expressly considered that it is, quote, relevant to compare the size of the targeted part of the protected group with the number of Croat victims in order to determine whether the JNA and Serb forces availed themselves of opportunities to destroy that part of the group. That is why those two particular figures are relevant. Contrary to what was suggested by the Gambia on Tuesday, I did not say, and indeed never have said, that the alleged death of 10,000 human beings is not substantial. That, of course, would be offensive. What I said was that, in remarkably similar circumstances to the Croatia case, the number of alleged victims in the present case is, quote, small in relation to the size of the targeted part of the group, unquote. And as such, as here, the Gambia has failed to show that the perpetrators of the acts which form the subject of the principal claim availed themselves of opportunities to destroy a substantial part of the protected group. On a similarly emotive subject, I must also address repeated reference by the Gambia to other numbers in this case, namely what it claims is that between 734 and 2,109 children under the age of 5 died during the military operations or were killed during flight to Bangladesh. That is incorrect. These numbers, in fact, derive from crude, highly unscientific statistical extrapolations from healthcare data and interviews with just 81 unknown persons, which can't possibly substantiate the numbers presented to you as concrete fact during these proceedings. It is because of these kinds of representations that Myanmar has descended into the details, because it is only through careful analysis that an accurate picture may emerge. The blizzard of statistics from the Gambia to which I have just referred is irrelevant. The Gambia has already repeatedly confirmed and unambiguously stated that, quote, the entire Rohingya population was targeted, unquote. Indeed, the Gambia is echoing the FFM's own contention that, quote, the operations targeted and terrorized the entire Rohingya population, unquote. That includes the 126,000 Rohingya living in the IDP camps in Sitwe, immediately adjacent to Rathidong Township. The Gambia, in its pleadings, has never sought to argue that they, that group of Rohingya, do not belong to the entire Rohingya population. And indeed, it expressly points to the actus reus, namely the commission of Article 2C, as having been inflicted upon, quote, all Rohingya in the internally displaced person camps. Yet through its statistics, the Gambia now tries to argue that that group, that same group, are not to be counted as part of the targeted group for the purpose of assessing dolus specialis. It is a flawed logic, and it is wrong. So, if reference to the fact that 126,000 Rohingya living in the IDP camps were entirely unharmed during 2016 and 2017, and remain so today, is, quote, a terrible argument, then that is a matter for Counsel for the Gambia to take up with his own colleagues and not to address to Myanmar. In the present case, the alleged targeted part of the protected group living in Rakhine State prior to October of 2016 stood at just under 1.4 million people. And it is against this figure that the number of proven victims falls to be considered. Irrespective of the inferences to be drawn from these facts and figures, they do not stand alone. As Dr. Staker reminded you yesterday, there are also undisputed facts that are inconsistent with any intention to destroy the protected group as such. These include the fact that the security forces, time and time again, eschewed numerous opportunities for such destruction, while many made their way to Bangladesh in huge numbers. In its second round, the Gambia placed emphasis on the alleged shooting of fleeing refugees crossing into Bangladesh. That is categorically denied, and there is simply no credible evidence that exists to substantiate that claim. It is based, like so many of the Gambia's claims, on vague and generalized materials, and it stands in stark contrast to the witness testimony to the contrary. Mr. President, members of the Court, that concludes my presentation. Throughout these hearings, a number of my colleagues have already strained the goodwill and forbearance of those working hard in the interpreter's booth to populate the transcripts with various literary references or nods to flora and fauna from their home countries. So I will end here instead with a simple expression of my sincere gratitude to the distinguished members of the Court, before whom it has been my distinct privilege to appear. Mr. President, I kindly ask you next to call upon Professor Talman to address the Court on the legal consequences of alleged breach of the Convention, but perhaps after the short adjournment.
I thank Mr. Blum-Cooper. Before I give the floor to the next speaker, the Court will observe a break of 50 minutes. The sitting is suspended.